Call the next case, Sylvia Walters versus NATIONSTAR. Good morning, sir.
Please the court. I'm Greg Horowitz. I represent the appellant, Sylvia Walters, in this foreclosure case. I believe that I've shown in the briefs that the original plaintiff, Aurora Loan Services LLC, did not prove standing. The case was filed by Aurora in August of 2010, and the note had an endorsement from the original lender, First National Bank of Arizona to National Bank of Nevada, and then it had a First National Bank of Nevada to blank.
Is that really I mean, the only issue is at the time that the lawsuit was filed, they didn't prove standing. I mean, the original note was introduced into the trial court, and the assignments and all of that. So
no assignments.
There weren't any assignments. There was evidence of assignments, right?
No, none.
No evidence of assignments?
No.
Okay. So what was introduced in the trial court?
That's the issue right there. Well, first of all, Your Honor, it came out in the middle of the trial that they weren't the owner of the note and holder. They were the servicer for a trust. That came out for the first time at trial, and there was no power of attorney from the trust under Elston. You have to have authorization from the trust in a securitized trust case. There's nothing in there. That came out at trial. That's an issue that I brought up in my reply brief. But what's very interesting is that Aurora Loan Services LLC, they attached this note that I just told you about with a blank endorsement, and then they filed it.
Blank endorsement can establish standing, can it?
Not under this situation.
It can generally.
Can.
Okay. So you're saying there were no assignments, there was nothing that was introduced, it was just they had the note and then that was it. They admitted the note and that was it.
Yeah, and the note they introduced is the issue. The note they introduced over objection, I raised Feltus because their pleading attached this note, their amended complaint attached the same note with this blank endorsement.
Well, there was an inconsistency between what was attached to the complaint and then what was actually admitted, right?
Right, the judge allowed.
That inconsistency is what establishes the fact that they didn't establish standing at the time.
One of the issues, because you really need to take a look, if you haven't already, the original note, which was filed about 3 years later, it establishes that, remember, this original note is from the original lender to another second bank, and then the second bank to blank. Okay. Original note comes in, that blank endorsement on the first page is stamped with another endorsement to another bank. And then there's an allonge transferring it from that bank into a trust, and then, which is key, then there's another allonge transferring it finally to Aurora Loans for the first time.
Assignments, those were the allonges that I was thinking. Okay.
So the first time that they showed standing according to the original note is when they got it was endorsed to them. So, and they never could explain, the witness was from the second servicer who took over the case, and they also didn't introduce a power of attorney from the trust showing that they had the right to bring it on behalf of the trust. Neither one of them did. And the only evidence of, I asked the witness, well, actually the appellee's counsel asked his witness, do you know if Aurora Loan Services held the note, basically, I'm paraphrasing, when the complaint was filed? Objection, hearsay, Your Honor. He works for the NATIONSTAR. You have to put the records in evidence before you can testify about them. overruled, sit down, I'll let you cross-examine. So that's their only proof. And when I cross-examined the witness, I asked him, do you have any documents to show that the original plaintiff held a note when the complaint was filed? No. So she did let this in. That was the only evidence, and it's hearsay, and I properly objected as such, and I cited SAS case and other cases, but...
Was there ever a motion to substitute parties?
Yes.
All right, and was all of this heard at that particular time?
Your Honor, that's a good point, and there's a recent case out, I can't quote it to you, but it states that, probably Mr. Stopa could, but there's a recent case out that states that the only time that an assignee doesn't have to prove it at trial is if the order allowing the change of parties makes specific findings that this person basically took an assignment and they are the proper party. It can't just be a simple order with no findings of fact. Then you don't have to prove it at trial. But when you get to trial, you have to prove everything. And they didn't put an assignment into evidence from...
Were any of the powers of attorney put into evidence?
No, there were no powers of attorney.
Agreement and no powers of attorney?
Nothing.
So there's no documentary evidence respecting the authority of these
No.
executions?
No, nothing. And, Your Honors, excuse me, the acceleration letter, the proof of mailing, there was no proof of actual mailing. It was the prior services record. He had no documents. I went through the testimony in my briefs, and
There was no certificate of mailing, there was a copy of a letter in the file, but there was no evidence that it had actually been sent.
exactly, and it was from the prior servicer, and I asked the witness, do you give a work for them, that kind of thing? So you have no knowledge of, in other words, under the evidence code, you can prove mail.
He didn't understand, he didn't know what their business practices were.
He didn't know that. He didn't have any document. He just said, well, under the boarding process, I just relied on it. What in the boarding process? Nothing.
Right.
Now, the third point, Your Honors, is that the address on the letter, not only didn't they prove it was sent, but they sent it to the wrong address. Under the mortgage, it has to be sent to the property address unless the borrower notifies the bank in writing to send it to a different address. In this case, they sent it to an address in Sarasota. This property is in Ocala, and there was absolutely no evidence whatsoever that the borrower informed the bank to send notices to any other address. And this was, there's two cases right on point that I cited in my reply brief, where at trial, the same situation, and after a trial, the appellate court reversed because of the language in the mortgage, and it's a contract between the parties, and they had the burden to put the something from the borrower in writing. It's also a summary judgment case I cited to you, the Ramos case in the brief, where a court entered a summary judgment, and in the same situation, they raised it as an affirmative defense. Instead of the property address, it was sent to a P.O. box, and the court reversed on the summary judgment. So it's been both at a trial and also summary judgment, and these are recent cases right on point. And based on these failings, Your Honors, I would ask the court to reverse and instruct the lower court to enter an involuntary dismissal. And I'll reserve 5 minutes.
Okay,
If I have that?
Yeah, you have 11 minutes.
Okay, thank you.
Okay, thank you. Morning, counsel.
Morning, please the court. Sarah Holiday Tobias on behalf of NATIONSTAR Mortgage. I'd like to kind of reset and recast what happened at trial. NATIONSTAR Mortgage was substituted as a party plaintiff before trial. And so at trial, as counsel aptly noted, we had to prove that we both had NATIONSTAR was the holder of the note entitled to enforce it at trial, and that we had to prove that Aurora had possession and was the holder prior to trial.
Prior to trial or prior
I'm sorry,
to
prior to the suit being filed.
Okay, could you help me, I guess, start with a couple of things. Number one, the documents that were introduced at trial, specifically the note and the allonges or endorsements, were not the same as the copy of the note that was attached to the complaint.
Correct. The note that was attached to the complaint, the original complaint, had an allonge and several endorsements that resulted in a blank endorsement. The note that was entered in at trial had an additional allonge that still resulted in a blank endorsement at the end of the day. So either way, whether it was, if you look at the note attached...
Doesn't that suggest, or at least require some explanation as to who was holding it? I mean, I don't dispute that the law allows the holder, you can endorse a note to me in blank, but the fact that it's got a blank endorsement doesn't indicate that I hold the note as opposed to Judge Sawaya holding the note. It says whoever's got this note has the rights of the holder. But it seems to me that you would have an affirmative obligation to demonstrate who's holding that note, because if I'm holding the note, I've got the right to endorse. If he's holding the note, he's got the right, and if you're holding it, you've got the right.
And that's correct, Your Honor. We would have to show not only an endorsement, either in blank or specially endorsed to whoever the plaintiff is at the time, but also possession or indicia of possession.
Okay, so how was that done? And I guess my concern is how this extra allonge or endorsement shows up that's not there when the complaint is filed, which calls into question, at least for me, who actually was holding the note.
Right. There were several pieces of evidence presented at trial that buttressed standing. There was the testimony of the witness himself. He testified that based upon his review of the records, that Aurora had both the original note and both allonges.
What's your response to opposing counsel's claim that that's all hearsay, which was properly objected to?
So as to the hearsay piece, his primary objection as to it being hearsay was that the underlying business record was not admitted into evidence that supported the witness's knowledge. And I would agree that there wasn't a record entered into evidence to support that, but I would say that at the same time it wasn't necessary in this instance. There's a distinction in the case law, including in the cases that the appellant has cited, that talk about when a corporate witness can gain knowledge, personal knowledge based on their review of the records, if it is information that they have access to and they have a reason to know based on their position. We would submit that this type of information, the dates of possession, the events of when endorsements were placed on the note, when allonges were received, that would be the type of information that can be gleaned from business records and form the underlying personal knowledge of the witness.
What was his explanation, if there was one given, of the fact that there was an additional endorsement or allonge on the documents introduced at trial, the note introduced at trial, versus what was attached to the complaint?
His testimony was that Aurora had possession of the original note with both allonges endorsed as it was presented at trial, and that the inference was that that foreclosure counsel attached the wrong copy, attached a prior version of the note.
He testified that the foreclosure counsel did that, or he just assumed that, or that was the inference that you gleaned from the testimony?
That's the inference I've gleaned from the testimony. He testified
All right,
that
help me with this, because I've made myself a little chart trying to follow the chain of assignments and allonges, and for whatever reason, banks seem to be incapable of dating any endorsement. I don't know why that seems to be so hard, but that seems to be an impossibility in the banking industry. Help me walk through the chain of endorsements as you see it.
Sure. So like I said, the original note has two allonges. The first allonge, as we've called it, is the one from First
The
National.
original lender is Bank of Arizona.
Yeah, so it's from First National Bank of Arizona, and there's a special endorsement by the First National Bank of Arizona to First National Bank of Nevada.
Okay.
And then there is on the copy that's attached to the complaint, there is a blank endorsement from First National Bank of Nevada. At the time of trial, the original note and what it showed was that it was then made a special endorsement to Residential Funding Co. LLC.
Okay, and there's also an assignment of mortgage from MERS to Aurora dated 7/16 of 10, which is right before the lawsuit's filed.
Correct.
How does that enter into all of this?
So following the chain of endorsements still, there's another on the first allonge attached to the original note. There's then a special endorsement from Residential Funding LLC to Deutsche Bank. And then you go to the second allonge, and there's a special endorsement by Deutsche Bank to Aurora. And then Aurora endorses it in blank. And that's how you get to the blank endorsement at the end of the day. What typically happens with MERS is that prior to...
What evidence was there in the record? For example, I'm looking at this in allonge from Deutsche Bank. It says Deutsche Bank Trust as trustee, formerly Bankers Trust as trustee for residential funding, formerly known as so-and-so, its attorney-in-fact. Was there a trust agreement or a power of attorney document introduced that would demonstrate that this wasn't the janitor that signed this? I mean, I'm not sure what a limited signing officer is. That's not a title I've ever seen in the corporate code, what limited signing officer is, but it seems to me that for me to draw any inference from that, I'd need to know what authority Company 1 gave Company 2 and who they gave it to. So how was all of that proved?
Well, as far as any powers of attorney, there were no powers of attorney entered into evidence because...
Can you tell me from the record, not from your own personal knowledge, but from the record, what is a limited signing officer?
I do not know. Based on the record, there's nothing in the record that would say that.
We don't know who that person is or whether the limited signing officer is where he or she might fit into the corporate hierarchy, whether she's the president or the custodian.
Right, but I would submit, Your Honor, that endorsements on a note are presumed authentic unless there is an affirmative defense otherwise, and then there's a specific showing that has to be
Where does that
made.
presumption come from?
It's in the UCC, and I don't have that number directly with me, but we've briefed it in numerous other cases. There is a presumption that the signatures on a note and the endorsements are presumed authentic.
Well, I don't think the question here is authenticity. I think it's authority.
Well, they're presumed authentic and authorized under the statute.
Well, but under the Florida Corporation Code, I mean, certain officers are authorized to sign things on behalf of corporations, presidents, vice presidents, secretaries, in some instances treasurers, but I have no idea what a limited signing officer is. I mean, that's not something I've ever seen before. And
Well, and there's nothing in the record that would provide that information, unfortunately, Your Honor. Like I said, what I would say to that is that we didn't have to prove the authority of each endorsement because they're presumed authentic and authorized under Florida law, the Florida statute, and I'm happy to find that for you momentarily. So what you have to look at the end of the day is the person who's bringing suit, do they have the note in their possession? And is it endorsed either in blank or specially to them? There is evidence that the original note that was put into evidence at trial had the endorsement to Aurora, and the witness testified that Aurora had possession of had the possession of the note plus both the allonges prior to the suit being filed. There's also the assignment of mortgage, which is attached to the complaint, and it's a public record, from MERS to Aurora to clean up the title issue as far as the mortgage itself. And then other indicia of standing, in addition to the allonge itself, there were several other things that were presented at trial that would show that Aurora was the entity that had the right to enforce the note. There was the testimony that NATIONSTAR was the current servicer, but the prior servicer was Aurora. And upon,
Talking about the hello letters?
well, there's the goodbye letter and hello letter, yes, so when it
That just
transferred.
indicates that Aurora was the servicer, or servicer of the note. It doesn't indicate on there anything about them being the possessor or the owner of the note, does it?
That's correct, but it also shows that they, and then you look at the pay history, which shows that they were making disbursements and collecting payments, and there is a case out of the 4th DCA.
Pay history doesn't show who was making the payments or who was accepting them.
The pay history shows that Aurora was making disbursements for like taxes and escrow related to.
Does the servicer necessarily hold the note? I mean, can I hold a note and say, you know, I want the payor of the note to pay you, and you're going to just deposit it into my account?
It depends on the case. I mean, there are.
Wouldn't that really be a situation that the holder of the note and the servicer have to have an agreement as to who's doing what to whom? And typically, we see this because we have trust agreements introduced into evidence that say, here's what your rights are, here's what my rights are. But here, you're asking us to assume that simply because someone is collecting the note, making disbursements, that they have the rights of a holder. And I'm not sure that that's what the law says.
I'm saying that's indicia to further bolster the fact that they were the holder. We have the testimony of the witness himself who said that they had possession prior to the case being filed.
Let me ask you to address, there are two issues, I guess, related to the letter, the default letter. One issue is that their counsel contends that there's no evidence. He's not disputing that the letter exists in your client's files. What he's disputing, as I understand it, is that there's no evidence to suggest that it was mailed beyond the fact that it exists. There's no testimony as to what the ordinary business practice was, et cetera. The second issue, as it relates to the letter, is that it didn't go to the address specified in the mortgage, and from at least what I could see, there was nothing to indicate that the mortgagor had designated some other address. Could you address those issues for me?
Sure, absolutely. So as far as the breach letter and no evidence of it being mailed, the witness at trial on behalf of NATIONSTAR testified, again, to the acquisition of the records from Aurora and talked about a 3-phase audit that was performed that checks the accuracy of the records, and he specifically mentioned the correspondence specifically, and when the default letter was discussed, he specifically referenced the default letter as part of that audit and check.
I think the question is whether I don't think he's disputing that the letter exists in your client's files and that they inherited that file from the prior servicer. I think what he's saying is that the mere existence of the letter in the file doesn't indicate one way or the other whether you actually mailed that letter.
Right, well, and as far as, so in addition to the audit process, the witness also testified that based on his review of the records and personal knowledge he gleaned from that review, there was a notation that the default letter was in fact mailed.
And where is that found in the record? Because I mean, I may just not recall it. We got so many cases today that.
Sure.
I didn't remember his testimony that there was some indication in the file that it was actually mailed, but I'm not saying that's not there.
And if you wouldn't mind, I'm going to have my associate help me find that while I address your other point.
That's fine. So I think we'll defer that issue for a moment, and then you can perhaps address the issue of
The proper
the
address.
address, let's assume it was sent for a moment, and let's talk about where it was sent.
Okay, so the mortgage, paragraph 15 of the mortgage allows the borrower to set forth a separate address if they want to receive notice at that address. Based on the records that are before the court, there is evidence that the borrower didn't, in fact, provide a second address, a notice address, as it's called.
Or did not?
Did, because there is the mailing address where the letter was sent is reflected as the notice address in the pay history as to where all correspondence were going. There is also the acknowledgement by counsel at trial that this was not homestead property. She didn't actually reside at the property address.
Well, but that isn't relevant. I mean, if I want my letter to be sent, if the mortgage designates that you're to send the letter on my behalf to Judge SYLVIA, that's our deal. So I guess my question is, if I understand what it says, is there's a presumption that you'll send it to the property address unless the mortgagor specifies a separate address. So what evidence is there in the record that she specified a separate address?
The fact that a different address is noted on the pay history as the notice address.
So you're assuming that you glean from that if it's there, she must have specified that as an address. You don't know where that came from. It's just in the pay history, so you assume they didn't pull it out of thin air. They must have gotten that from her.
If it's on the pay history as her notice address, she would have had to provide it to them as such.
But there's no direct evidence as to
There is
where
no direct testimony to that, no.
All right.
And as to the actual proper address issue, assuming the letter is sent for a moment, we would argue that even if it was sent to the wrong address, if the proper address was actually the property address, there was no prejudice. It was a non-material breach of the conditions precedent under Allstate versus Farmer that this court decided in 2012, and then Vasilevsky from 2015, also from this court.
But in Vasilevsky, we said that the reason that we were finding that there wasn't prejudice was that the letter substantially complied. It had most of the stuff. It was short a day instead of 29 days.
It was 3 days off.
It was a couple of days off.
Right.
Here, the question is, was the letter sent at all? And you would agree that if the letter wasn't sent at all, or it was sent to the wrong address, it's hard to find substantial compliance.
I would say if it wasn't sent at all, that would be a hard sell on substantial compliance. But if it was sent to an address where she routinely receives mail,
If you prove that, I would agree with you that I would have a hard time demonstrating prejudice if it was sent where she routinely received mail. But maybe, I think your colleague has found what she was looking for.
it's on page 32, or it starts on page 32
Of the record, or?
of the transcript. And it starts at page 32 of the transcript, line 2. Now, were there any indicators that the breach letter was sent and the records received from Aurora? And then there's some discussion of...
This is your client's servicer that's testifying now?
Correct.
Okay.
Well, it's NATIONSTAR
Right.
who's testifying. And there's some back and forth between counsel. And then it proceeds on to page 33. Now, on what date was the letter purportedly sent? This was sent or dated on May 21st, 2010. Then it goes through who it was addressed to, at what address. It was the mailing address regarding the property address of 5245 Southeast 70th. So he's testifying that there were indications and that it was sent, or to the mailing address.
Did Aurora ever receive any mortgage payments at all from?
Yes.
How many?
They received mortgage payments up until
Or how many, or for what length of time?
the default. So the original mortgage was November 17th, 2006, and the payment default was April 1st, 2010. And the Aurora began servicing.
I'm talking about when Aurora started the servicing. Did Aurora ever receive any payments?
Yes.
Directly from the?
Yes.
Okay, how many?
Aurora received monthly payments starting in April 2008 through the default in April 2010, so 2 years worth of payments.
All right, counsel, you're down to 8 seconds.
think I'm good.
Get up, say thank
Unless the
you.
court has any other questions, I think that I have
Thank you very
explained our
much.
position. Thank you.
We could just get him to agree with everything you said. Out of here.
Your Honors, I just want to, there's a fundamental misunderstanding about an assignment, and it was introduced in the answer brief. And the fundamental misunderstanding is that it's not in evidence. It's not. And under the Beaumont case,
When I asked you before about assignments, you said there just weren't any, but now we know that there was some assignment, it just wasn't placed in evidence, right?
correct. So that's the equivalent of there not being an assignment.
You're talking about the assignment from MERS to Aurora,
to-
dated
That's not,
July
yes,
16th.
it's not in the evidence.
Was it, it was testified to, but the
No.
document, it wasn't?
No.
And how is it in the
Where
record?
did I come up with it? I mean, I
It's
have it in my
attached,
notes.
it's attached to their complaint, Aurora's complaint, which is not evidence. It's not in
It's
evidence,
in the record then, but it's just, you're just saying it's not evidence.
right?
The record
And under the Beaumont case and the Correa case, if it's not in evidence, it doesn't count. And I went over that in the brief. The other thing, so there is nothing, all right? And
Well,
as-
you agree that if the allonges and endorsements suggest or demonstrate that they held the mortgage, held the note at the time of the institution of the lawsuit, that the mortgage is an incident there too.
Sure.
And the assignments are really irrelevant.
absolutely.
So really, it's, I mean, where the rubber meets the road here is if we look at all the endorsements and figure out whether that demonstrates that they did or did not prove that they were the holder at the time they filed the lawsuit.
Right.
That's, the assignment's really somewhat irrelevant.
Right, right, but there, you can, well, obviously, you can prove it either way.
Right.
Right, and a lot of times.
They didn't introduce it, that doesn't necessarily put a nail in their coffin, it just doesn't help.
Right, they were arguing, and they said there's an assignment attached to the complaint. That's how it was introduced into this subject matter, and I just want to make it perfectly clear that it's not part of the record.
What was your response? I mean, did you admit the existence of it or deny
No,
it?
it
or-
didn't discuss it. It wasn't an
No,
issue.
in your answer, did you admit, deny, or?
Deny. Alleged standing as an affirmative defense, I deny. And, Your Honors, as far as that proof of mailing, if you actually read all of the testimony, counsel read you a part of it, and then she said there was a bunch of dialogue. Well, the dialogue was a hearsay objection, which the court overruled. I said, there's no documents and evidence about Aurora's, anything showing it, and, you know, the judge, you know, she was not going to listen to me at all, and she just allowed it in, and over my hearsay objection, and then I went and cross-examined him, and he admitted he's got no documents. I pinned him down. Sir, so you have no documents from Aurora with you in court today to show that this was mailed. Isn't that correct? I have nothing. So that's what he said. Unless you have any further questions, I'm going to ask that it be reversed and with instructions for an involuntary dismissal.
All right, sir, thank you.
Thank you. And I just want to say you have a beautiful courtroom.
Thank you. Thank you very much. All right, we're going to take a morning break.